Hello and welcome to the Unpacking the Cybercrimes Act webinar. While we wait for all the attendees to join, let us cover the housekeeping rules for this webinar. Today's webinar is scheduled to last 1.5 hours, including the question and answer section. All participants will be muted to enable the speakers to present without interruption. Questions submitted prior to an hour before the start of the webinar will be answered first during the question and answer section. Any additional questions can be submitted via the chat room during the webinar at any time. These will be answered if there is enough time after the pre-submitted questions. There will be no interval during this session. The recording of this presentation will be provided approximately 72 hours after we conclude the session. Hello and welcome to the Unpacking the Cybercrimes Act webinar. While we wait for all the attendees to join, let us cover the housekeeping rules for this webinar. Today's webinar is scheduled to last 1.5 hours, including the question and answer section. All participants will be muted to enable the speakers to present without interruption. Questions submitted prior to an hour before the start of the webinar will be answered first during the question and answer section. Any additional questions can be submitted via the chat room during the webinar at any time. These will be answered if there is enough time after the pre-submitted questions. There will be no interval during this session. The recording of this presentation will be provided approximately 72 hours after we conclude the session. Hello and welcome to the Unpacking the Cybercrimes Act webinar. While we wait for all the attendees to join, let us cover the housekeeping rules for this webinar. Today's webinar is scheduled to last 1.5 hours, including the question and answer section. All participants will be muted to enable the speakers to present without interruption. Questions submitted prior to an hour before the start of the webinar will be answered first during the question and answer section. Any additional questions can be submitted via the chat room during the webinar at any time. These will be answered if there is enough time after the pre-submitted questions. There will be no interval during this session. The recording of this presentation will be provided approximately 72 hours after we conclude the session. Hello and welcome to the Unpacking the Cybercrimes Act webinar. While we wait for all the attendees to join, let us cover the housekeeping rules for this webinar. Today's webinar is scheduled to last 1.5 hours, including the question and answer section. All participants will be muted to enable the speakers to present without interruption. Questions submitted prior to an hour before the start of the webinar will be answered first during the question and answer section. Any additional questions can be submitted via the chat room during the webinar at any time. These will be answered if there is enough time after the pre-submitted questions. There will be no interval during this session. The recording of this presentation will be provided approximately 72 hours after we conclude the session. Hello and welcome to the Unpacking the Cybercrimes Act webinar. While we wait for all the attendees to join, let us cover the housekeeping rules for this webinar. Today's webinar is scheduled to last 1.5 hours, including the question and answer section. All participants will be muted to enable the speakers to present without interruption. Questions submitted prior to an hour before the start of the webinar will be answered first during the question and answer section. Any additional questions can be submitted via the chat room during the webinar at any time. These will be answered if there is enough time after the pre-submitted questions. There will be no interval during this session. The recording of this presentation will be provided approximately 72 hours after we conclude the session. Hello everyone and welcome to the Unpacking the Cybercrimes Act webinar. Your host for this webinar is Leandri Erasmus, and she is the Creative and Content Director of Upskill Academy. We want to thank our guest speaker, Leandri Pretorius, from Zella Tech Law for joining us today. We are all looking forward to her presentation and the information she will be sharing with us today. Before I hand it over to Liesl, to introduce Leandri, we would like to take a short moment of your time to introduce you to Upskill Academy. Upskill Academy is the creators of simplified courses for sometimes complicated yet current, relevant, and mostly required learning for compliance with various laws. The aim is to quickly, easily, and affordably upskill your workforce with the relevant information required for compliance with regulatory matters that may have far-reaching and negative effects on your business. The internet is your classroom. Study anytime, anywhere on any smart device. Train, verify, certify in 3 easy steps. Our training is a perfect solution with minimal disturbance yet maximum impact. Our courses are quick to complete, packed with all the needed information with graded questionnaires and a certificate of completion as proof of training and compliance. Companies are fully embracing e-learning and online learning platforms due to their simplicity of use. We offer the ability to monitor student performance and progress and offer completion of compliance certificates. Cost-effectively mitigate risk for your company. So, how does it work? Courses can be purchased separately per individual or bulk access tokens can be purchased. We cover a wide variety of topics in our course library. Some of these topics include cybersecurity awareness training, POPIA employee compliance training in ethics, fraud, bribery and managing the risk training and so much more. The best part, the library constantly grows. Need a course that is not available in our library? No problem, we can and will research and develop it for you. The first step is to choose which course you want to enroll in. Step 2 is to log into your profile and get started. All courses consist of modules with videos followed by short questionnaires. The system automatically saves your progress so you can do the course over time. The system also has course compliance controls that require video completion to move on from one module to another. As soon as you've completed all the modules and passed the graded questionnaires, you will receive a certificate of completion. All certifications will remain on the Upskill Academy platform for future access if required. Train, verify, certify in 3 easy steps. Here are just a few testimonials. For more information on the courses we offer, contact us today.
Hi, good morning everybody and welcome to the Unpacking the Cybercrimes Act webinar this morning. We look forward to everything that Leandri is going to share with us. I would like to introduce you quickly to Leandri. She is a technical law advisor from Zella Tech Law, and she is going to explain to us completely what the Cybercrimes Act means to yourselves as a company, what you should do to prepare, and what you should know about the Cybercrimes Act. Leandri, I'm going to hand it over to you. Thank you.
Thank you very much, Liesl, and to Upskill Academy for having me. Yeah, it's a pleasure to be here, and I look forward to presenting this session today. Thank you for all the attendees taking the time to attend this webinar. I'm going to share my screen. Liesl, just confirm when everything is in order and you can see my screen.
Yes, we can see. Thank you, Leandri.
Okay, sorry about that. I'm just going to stop my video just to make sure everything works properly. Okay. So yes, thank you to everyone for being here today. With that, let's get started. So I will start with a brief introduction, going over some cybercrime statistics, after which I will jump right into the Cybercrimes Act, the structure, how it is set out, and then after that, I will go into how it overlaps with other pieces of legislation, because it is a piece of legislation that does not operate in isolation. Lastly, I will then cover the practical considerations that organizations need to take in light of what is in the Cybercrimes Act. So starting off, giving you some statistics, Forbes released an article indicating statistics around cybercrimes that occurred in 2021. As you can see there, it's been quite a trying year for cybersecurity, with quite high-profile cases happening, data breach incidents, ransomware attacks, critical infrastructure and supply chain security weaknesses being exploited. So on this image, you can see that about 20, this is a global statistic, so $20 billion is the total cost of ransomware attacks in 2021. 32% of victims paid ransom demands in 2021, and of those paying victims, only 65% of their data was recovered, even though they did pay the ransom. Projecting a bit into the future, there you can see in 2031, ransomware is expected to cost globally $265 billion. Looking at South Africa has been reported to be to have the third highest hit rate globally in terms of cyber crime, losing about 2.2 billion rand annually to cybercrime. So with those statistics in mind, let's get into the Cybercrimes Act. So just a brief history of the Act. It started out as the Cybercrimes and Cybersecurities Bill, which contained provisions on both cybercrimes and cybersecurity. However, due to certain freedom of speech concerns and the wide powers granted to government in that bill, it was then split into two separate bills, being the Cybercrimes Bill and the Cybersecurities Bill, from where the Cybercrimes Bill was signed into law in May 2020, and the Cybersecurities Bill is still is not in force yet. It hasn't been signed into law yet. So the Cybercrimes Act, after being signed into law, it didn't come into force immediately. Only some of its provisions came into force in December 2021, and other provisions are still not yet in force. But as I go through the slides, I will indicate which provisions are in force and which are not yet in force. So the aim of the Cybercrimes Act is to create one piece of legislation where cybercrimes are put out. It also criminalizes the disclosure of harmful data messages, and it regulates the jurisdiction of South African courts in respect of cybercrimes. So it brings together cybercrime regulations in one piece of legislation. So as mentioned, this act does not operate in isolation, and it overlaps with certain other pieces of legislation, such as the Electronic Communications and Transactions Act, the Protection of Personal Information Act, and the Films and Publications Amendment Act. I will cover those further down in the slides. Looking at Chapter 2 of the Act itself, it splits cyber offences into cybercrimes and malicious communications. So under cybercrimes, you can see some of the offences are unlawful access to a computer system or data storage medium, unlawful interception of data. This one is important later on in terms of the RICA Act. I will cover that under practical considerations, but just note that as I get to practical considerations. So another offence is an unlawful act in respect of software or hardware tools, unlawful interference with data or a computer program, unlawful interference with a computer data storage medium or computer system, the unlawful acquisition or possession or provision of a password or access code or similar data, cyber fraud, cyber forgery and uttering, cyber extortion, aggravated offences, and then theft of incorporeal property. Malicious communications refer to data messages that either incite damage to property or violence, or it threatens persons with damage or damage to property or violence. So it also covers the disclosure of a data message, including an intimate image. So you can see here there's quite a broad range of cyber offences included in this act, and also attempting or conspiring or aiding, abetting, inducing, inciting. Any of these offences is also an offence under the Cybercrimes Act. So furthermore, now that the offences have been set out, the Cybercrimes Act also covers competent verdicts, which means that if the evidence in criminal proceedings show that, for example, if a person is charged with, say, cyber fraud, but the evidence led in the criminal proceedings do not prove the commission of cyber fraud, but instead proves the commission of another related crime, then they will be found guilty of the crime which is proven. So this also includes attempting, conspiring, aiding, abetting, inducing, inciting, any of those offences. So it's not, it has a quite wide-ranging effect in terms of what you can be found guilty of. So sentencing, once you are found guilty of either of the above offences, you will be either charged with a fine or imprisonment not exceeding 5 years or 15 years. There's a range depending on the type of offence committed. In some cases, you can be liable for both a fine or imprisonment. Also, where there's no penalty prescribed for a particular offence in this act, the court can impose penalty under Section 276 of the Criminal Procedure Act. So once again, the penalties under this act are also quite wide-ranging, and as I will discuss later on, it's not only individuals that can be found guilty, but companies as well. So another rather important provision in the Cybercrimes Act is the provision dealing with orders to protect complainants from harmful effects of malicious communications. Although this section is not yet in force, when it does come in force, it will become important for electronic communications service providers, as I will indicate now. So this provision indicates that pending the finalization of criminal proceedings, the party that reported the offence or the party, the complainant, can approach a magistrate's court for an order to prohibit further disclosure of that particular data message, or for an order to order electronic communication service providers to remove or disable access to that data message. So, for example, if someone has been the victim of revenge porn, and then that intimate image of theirs is being distributed, or it is on a social network, they can approach a magistrate court to prohibit the further disclosure of that data message, or to order the electronic communication service provider to remove it or to disable access to it. And the court can also, where the identity of the person who distributed the data message is unknown, the court can order an electronic communication service provider to provide it via affidavit, the electronic communications identity number of where that data message originated, as well as the name and surname and ID number or address, any information that links that electronic communications identity number to the person who is connected to that number. So that should be noted for when this comes into force. These obligations will fall on electronic communication service providers. Now, looking at the jurisdiction of the Act, I know that was one of the questions asked before the webinar. So this Act provides quite a broad range of jurisdiction for South African courts, in the sense that it allows South African courts to hear matters where the accused has been either arrested in South Africa or on a South African vessel or ship or offshore installation, or is a citizen of South Africa, or is ordinarily resident in South Africa. And here you can see a company registered or incorporated under South African law will also fall under the jurisdiction of the South African courts if the company is accused of being part of committing a cyber crime. And also any other body of persons, corporate or unincorporated, in South Africa. Also, where the offence or any act in preparation of committing the offence or any act necessary to commit the offence was committed in South Africa or on a South African vessel or ship or offshore installation or aircraft registered or required to be registered in South Africa at the time of the commission of the offence. So you can see here, it's not only the actual offence that can lead to South African courts having jurisdiction. It is the other acts or activity surrounding that offence that can also lead to a person or a company being tried in South Africa for the offence. Also, where the offence affects any person or restricted computer system or public body or any business in South Africa. So it doesn't necessarily mean that the offence needs to be committed in South Africa. Where it affects a person or a business or a restricted computer system in South Africa, the South African courts will have jurisdiction over it. So in cases where the offence was committed outside of South Africa against any person who is a citizen of South Africa or ordinarily resident in South Africa, the South African courts will have jurisdiction. And as I refer to the restricted computer system, that refers to a computer system under the control of or exclusively used by a financial institution or an organ of state, and this includes a court and which is protected, or an organ of state which is protected by security measures against unauthorized access or use. So also a company incorporated in South Africa can, if the offence was committed outside of South Africa and affects a company incorporated or registered in South Africa, the courts will have jurisdiction. And there it just expands further on what point 3 means by those parties being affected by the offence. Those in that case, the South African courts will have jurisdiction over the offence committed. So if an act constituting an offence under this act was committed outside of South Africa, this is another instance in which South African courts will have jurisdiction over the matter if the offence was committed outside of South Africa. This is if the accused is extradited to South Africa, or if the accused is found inside of South Africa and there is no application to extradite the person outside of South Africa, or the person outside of South Africa. So there you can see this specific 3, 4, and 5 indicates the very broad range of jurisdiction or circumstances which will give the South African courts jurisdiction when an offence under this act is committed outside of South Africa. So in order to prosecute an offence that was committed outside of South Africa within South Africa, this may only be done with the written permission of the National Director of Public Prosecutions and before a court that was designated by the National Director of Public Prosecutions. So when that accused is arrested or taken into custody, the accused must be presented with this written permission and designation of the court, and the original documents must be handed in at the court where the proceedings are to commence. But the National Commissioner and National Head of the Directorate, in consultation with the National Director of Public Prosecutions, must issue directives for police officials to comply with in this regard. I know there was a specific question about prosecuting offences in South Africa, so this is just to address that question. But the point of these slides is to just indicate that South African courts do have, there's a wide range of circumstances that will give South African courts jurisdiction when a cybercrime has been committed. So moving on to the South African Police Services and their powers to investigate, search, access articles, and seize articles. So the Act provides that the Criminal Procedure Act applies insofar as it is not inconsistent with the Cybercrimes Act, meaning that search and seizure provisions in the Criminal Procedure Act will apply insofar as it is not inconsistent with this Act. So this Act gives the South African Police Services the power to search for articles, access or seize any article, either with a warrant or without a warrant. With a warrant if they apply to a magistrate, or without a warrant in 3 particular circumstances. Firstly, if a person with the necessary lawful authority provides consent for the search or seizure to be carried out without a warrant. Alternatively, if the police official has reasonable grounds to believe that a search warrant will be issued if requested, and delay in requesting the warrant will defeat the purpose of the search and seizure. Alternatively, if they have already arrested the person who has committed an offence, or where they have reasonable suspicion that the person has committed an offence, they may search this person and seize articles that they find on him that they believe to be used in the commission of the offence. So another obligation to note for electronic communication service providers and financial institutions is any person or electronic communications service provider or financial institution that is in control of a container or premises or vehicle, facility, ship, aircraft, data, computer program, etc., that is subject to a search warrant. So if the police obtained a search warrant to search any of those items that is in control of any person or electronic communication service provider or financial institution, those parties must provide technical assistance or any other assistance as may be reasonably required from them to the South African Police Services or an investigator in order to assist them with the search or the seizure of those articles. So there is obligations on those parties to provide assistance to the police or investigators if they are so required, and if there is a search warrant in respect of those articles. Other sections that are not yet in force are sections dealing with the provision of false information under oath, which is an offence requiring electronic communication service providers to comply with certain directions around preserving data and evidence. That's not yet in force, but it is anticipated to come in force down the line, and sections on foreign state orders. So those are other, in terms of preserving evidence and data, those will become obligations on electronic service providers, electronic communication service providers in future once those provisions come into force. Then moving on to Chapter 5 and Chapter 6. Chapter 5 deals with mutual assistance received from foreign states. So in the event that, for example, the offence was committed outside of South Africa and affects a business or a person inside of South Africa, these mutual assistance provisions would apply once it comes into force, with authorities from the foreign country assisting South African authorities in the investigation of the offence. Chapter 6 then provides for a designated point of contact, which must be established by the National Commissioner. This is a point of contact which should be established within the South African Police Services as a point of contact for the public and to assist with proceedings and investigations. So this is aimed to speed up the process of proceedings and investigations, and the National Commissioner is mandated to equip and maintain this point of contact. However, this is also not yet in force, but once it comes into force, the National Commissioner will have 12 months from that date in order to establish this point of contact. Now, very importantly, reporting obligations under the Cybercrimes Act. Section 54 places reporting obligations on electronic communication service providers and financial institutions. Although this is not yet in force, it will become very important once it does come into force, as it requires these parties to report cybercrimes to the South African Police Services without undue delay and no later than 72 hours after becoming aware of the incident. And it also requires them to preserve any information that may be of assistance to the police service with regards to the incident that happened. And failure to do so could lead to a fine not exceeding 50,000 Rand. So once this provision is in force, electronic communication service providers and financial institutions will have to pay attention to when this obligation arises and how they will handle a response to an incident in order to avoid any penalties under this act. Section 55 is in force, and it deals with capacity building of the South African police services regarding their training in detecting and preventing and investigating cybercrimes. So this is the responsibility of the cabinet member that is responsible for policing to put in place training for the South African police services and build their capacity in order to handle incidents of cybercrimes. Okay, so with that was the structure of the Act and the important provisions to consider. So I'll now be moving on to how this Act interacts with other pieces of legislation. So I will start with the Electronic Communications and Transactions Act. The ICTA provides for the facilitation and regulation of electronic transactions. So before the Cybercrimes Act came into operation, cybercrimes were found in ICTA. But with the coming into force of the Cybercrimes Act, the Cybercrimes Act repealed those sections dealing with cybercrimes that was held in ICTA. So you can see from these above listed cybercrimes that used to be in ICTA, some of them are now in the Cybercrimes Act, and then new offences were added in the Cybercrimes Act. So also on top of that, the Cybercrimes Act adds these reporting requirements of electronic communication service providers and financial institutions, whereas previously that was not as succinctly set out in previous legislation. Then looking at the Protection of Personal Information Act and its overlap with the Cybercrimes Act, the POPIA provides for the protection of personal information, and it provides minimum requirements for the lawful processing of personal information. This act does not create any new cyber crimes, but it requires responsible parties, which is any person that is responsible or that determines the means and the purpose of processing of personal information. So that can be an individual or a company. It requires those parties to comply with security safeguards and to put with the security safeguards conditions in the Act. And it requires them to place or to put in place technical and organizational measures that will prevent the loss of and damage to or unauthorized destruction of personal information, and to prevent the unlawful access to personal information. So the Cybercrimes Act, in its interpretation section, states that where a responsible party fails to comply with the conditions of the POPI Act and a cyber offense occurs, that incident will be dealt with under the POPI Act. So it means that if a cyber offense occurs and personal information has been compromised, and it is found that the responsible party did not comply with the conditions of the POPI Act, then that will be dealt with under the POPI Act, not under the Cybercrimes Act. However, seeing that it is still a cyber offense that occurred, there will reporting obligations will arise under both the POPI Act and the Cybercrimes Act. So it's very important for companies to sort of know their duties under these two acts, to know when their obligations arise in terms of these acts. So the technical and organizational measures referred to there on the slide refers to the technical aspects thereof, refers to the IT measures that a company needs to have in place to ensure that personal information is secure and is not unlawfully accessed. And the organizational measures that need to be put in place refers to internal policies and training that needs to be established within a company to prevent mismanagement of information or negligence, or and to be able to demonstrate compliance under the POPI Act. Then, as you will see from the next slide, Section 54 of the Cybercrimes Act deals with the reporting obligations of electronic communication service providers and the financial institutions. So this is where a company's obligations can arise under both acts, is when a cybercrime occurs and, for example, information is unlawfully accessed. Does that information contain personal information? Then under Section 22 of POPI, the company will have to report to the information regulator that a data breach occurred. And if the data subjects are identifiable from that personal information, the data subject will also need to be informed about this data breach, possibly affecting their personal information. But because it is also a cyber crime that occurred, and once this Section 54 comes into force, if the company is an electronic communication service provider or a financial institution, they will then also have to report within 72 hours. They will have to report the offence to the South African Police Services and preserve any information that may be of assistance to the police. So it's very important to have internal policies in place to regulate incident responses of the company and how to deal with these reporting obligations. Then we have the Films and Publications Amendment Act. This act, so it amends the Films and Publications Act by inserting and amending certain definitions, which provides for the regulation of online distribution of films and games, and it extends the compliance obligations of the Films and Publications Act and the compliance and monitoring functions of the Films and Publications Board. It extends this to online distributors, providing that the obligations of internet access providers regarding, so it basically provides for the curbing of the use of internet service providers' services in distributing prohibited content, and it revises and strengthens the penalties in this respect. So Section 18F provides that it is an offence to distribute private sexual films or photographs without the consent of the subject of the film or photograph, and where there is intent to cause harm. So further, Section 18F subsection 6, for the purposes of this section, the internet service provider shall be compelled to furnish the board and members of the South African Police Service with information of the identity of the person who published the private sexual photograph. So this act regulates online content distribution, and it also places obligations on internet service providers to furnish information about a person who commits an offence, that information must be provided to the Films and Publications Board or to a member of the South African Police Services. Now, as you can see from Section 16 of the Cybercrimes Act, which criminalizes the disclosure of a data message of an intimate image. So private sexual photograph and intimate image is very similarly defined in these two acts. The application of the act and which act will be used in the commission of either offence is what comes into question. So so for example, if there's non-compliance with the Films and Publications Amendment Act, this will be then dealt with by an investigation from the Films and Publications Board. And if they find that there's merit in the complaint, they may order a takedown notice under the Electronic Communications and Transactions Act, which orders the internet service provider to take down the private sexual photograph or prohibited content. The limitation to this act is that it applies only in South Africa, whereas the Cybercrimes Act has a much wider jurisdictional area, or has much wider circumstances for where the South African court's jurisdiction can come into play. So which act will be used in order to enforce or to prosecute the offence will determine on the circumstances of the particular case. So now moving on to the practical considerations that companies need to consider, and looking at the organization's readiness in terms of being secure against cybercrime and responding to cybercrime. I'll show you here a slide from the SLS store. So they've taken, they've looked at a study from Proof Points 2022 Cost of Insider Threats Global Report. And this is a visual representation of that report, looking at insider threats to a company. So here you can see that 56% of insider threats is a result of negligence. 26% is a result of a criminal insider, and 18% is a result of credential theft. So from this slide, it shows that managing and training staff and having internal policies to regulate the operation of the company is extremely important. Managing the company's resources is extremely important in fighting cybercrime. So now looking at some of the steps that a company needs to take in order to ensure its organizational readiness. First off, companies should consider adopting a comprehensive company-wide cybersecurity strategy. This should be a strategy taking a top-down approach, with management fully on board and fully aware of the processes, so that the team can effectively implement this strategy and drive the cybersecurity agenda of the company. So this strategy will be a comprehensive strategy taking into account. So the cybersecurity strategy will be the broad outline of the company's approach to dealing with cybersecurity, and then from there the company should take gradually a granular approach. So, for example, looking at training and awareness for employees and management, because it's important because any strategy or policy, any document regulating the cybersecurity approach of the company is not going to be very effective unless employees and management understand the risks and know what their roles and obligations are in terms of implementing the company's strategies and policies. Then looking at implementing the technical and organizational measures required by the POPI Act. So this could, for example, be implementing network security management and information security management, such as firewalls, virus protection, encryption of company devices, for example, laptops and company-approved USBs. It's important also to have policies around company devices. Are employees using their own devices, or are they using company devices? And how do they handle this data storage devices? Can they use any USB or any hard drive, or should they use only company-approved USB devices and hard drives? This makes it easier to control what is happening within the company and to know where the threats and the risks lie. Also looking at access or restricting access to certain information, which employees should have access and which should not have access. Looking at password protection, separation of shared drives, and then also considering additional certifications, such as ISO certifications where those are applicable. For example, looking at ISO 27001, the information security certification or standard, this is designed for information security management, and it can help protect the confidentiality, the information integrity, and the security of information and information systems within the company. So it's important to consider which of these standards apply to your company and what are the requirements under those standards. So the ISO 27001 also focuses on risk and how to mitigate risk to information systems. Sometimes it also requires implementing data audit trails, which is an implementation that could help the company identify to track where data goes in the information in the organization, as well as being able to identify who is responsible for accessing that data. So this can also be, data audit trails can also be used to identify potential data breaches. It can be used to identify intrusions into secure data systems, and so that's an important tool to consider using to secure your information and your information system. And it can also, under ECTA, be used as evidence in court, seeing that the Electronic Communications and Transactions Act does not limit the provision of evidence merely because it is in the form of data and not physical evidence. So that's an important consideration, looking at tracking your data and determining who could be the offender within your system. It is also important to consider implementing business processes between departments for approval before accessing sensitive information. So how departments in an organization function and how information is spread between departments. This is a very important consideration in order to track the information within your organization and to regulate the data flow within the organization. Then doing regular vulnerability testing of the information system by the IT team. This is important to keep up to date with vulnerabilities and changing security requirements. So having an IT team that regularly tests vulnerability in your system is also very important. Now getting to regulate or tracking and monitoring your network for any suspicious activity. This becomes very important when you look at the RICA Act, being the Regulation of Interception of Communications and Provision of Communication-Related Information Act. So this act provides that if the company intercepts communication of its employees in order to monitor it and to surveil it in a sense, the company requires the employees' consent before doing so. If they don't have that consent, it will be regarded as unlawful interception of communication, which under the Cybercrimes Act is an offense, and under the RICA Act is also unlawful. So this is an important consideration when you're looking at your employment contracts. There has to be a clause in the employment contracts indicating that the employee consents to the monitoring of their activity and their communications. Further looking at policy development within the company. So this refers to internal policies and procedures that the company will create in order to demonstrate compliance with the POPI Act as well as the Cybercrimes Act, and also to regulate how the company deals with information within the company and how it deals with data breaches or cyber offenses or cyber attacks, and how it will respond going forward. So very important policies to have for a company is an organizational privacy policy. This will deal with how the organization deals with personal information in its control. Then classification of data policy. This is important to set out what types of data the organization deals with. For example, is it personal information? Is it confidential information? Is it special personal information? For example, information around health, race, biometrics of parties. Does the organization deal with data regarding children? So this is very important to classify the types of data in order to be able to track what needs to be done and to stay on top of the obligations that arise from handling certain data. Then there's various information security policies that can be implemented, incident management policies. For example, who needs to report to who? How does the company respond internally, and how will it respond externally? Does it need to assist the police? Does it need to notify data subjects? Does it need to hold off on notifying any person because the criminal investigation might be affected if certain people are made aware of the incident? And this links to external reporting protocols and internal reporting protocols. So how will the company deal with an incident, and who is involved, and what obligations need to be covered? Then following that, a business continuity policy is also extremely important in the sense that it is a document setting out the risks of a business. So in this policy, you will define the business risks. You will determine how the business will be affected by those risks, how to mitigate those risks, and how to proceed in the event of disaster or a cyber attack. Or a business continuity policy usually doesn't only deal with cyber attacks. It covers other disasters such as fire, floods, weather-related events, but obviously a cyber attack can bring a company to a halt. My apologies. So that is a very important policy to implement in order to set out how the business is going to go about operating or dealing with a cyber attack in order to not lose too much resources and not to be brought to its knees completely. On the other hand, considering remote working policies, in the time of COVID and following COVID, many companies now have either a hybrid working policy or are completely remote, or in the event that it's a flexible system, organizations will have to consider how they will go about dealing with employees who work remotely. Are there limitations on how those employees should work? Again, which equipment should be used? Is it the company's equipment or the person's equipment? And how to regulate the flow of data when now you're dealing with networks that are potentially not, you can't, the company can't control, okay, this is now the company's network that the employees are working on. So it's easier to control the security of that network. Now, if they are working remotely, you sit with other considerations in terms of securing networks and information. So that remote working policy is an extremely important consideration as well. And then looking at regular internal training. So now that all these systems are in place and the policies have been considered and implemented, staff and management will need to be continually trained and updated on new developments and given refresher courses on the company policies as well as the laws that regulate cybersecurity. So that is a continual aspect that an organization will need to consider. It is not a once-off training session that will suffice. It is something that needs to be maintained and continually looked after. So that covers the main practical considerations that companies need to take into account in light of the Cybercrimes Act. I do see that there are comments in the chat. Let me just ask Liesel, were there other questions to be answered before I have a look at the chat?
Leandri, no. The other questions, we had one other question that was submitted, but you did answer that question during the session. So you're more than welcome to continue and answers Jenna's question. And then we can proceed to the other questions. Everybody that has any questions, you're more than welcome to add them to the chat now. Do you want me to read the question, Leandri, or are you going to read it?
It's okay, I'll read it. I can see it here. So Jenna asks, please can you expand and clarify on the obligations of employment contracts under RICA? Mentioned under the practical consideration slide, it was mentioned that the employment contract should enable monitoring and surveillance consent. Is this an employee consenting to monitoring and surveillance of themselves by the employer? Jenna, yes, this is allowing employers to have access to, for example, emails of employees and other communications of employees. So this is very important to have in the employment contract so that the employee is aware that the employer intends to monitor these communications and for what reasons, and also to avoid the employer being liable under the Cybercrimes Act for unlawful interception of data, and also under RICA for unlawful interception of communication. So this is the employees consenting to the employer monitoring their communications. But this obviously has to do with work-related communications. Personal communications, on the other hand, would fall outside of that, unless unless there's application to work and it implicates the work situation or incident, but it mainly applies to work-related communications.
And then I see Andrew asked, is it possible to get a copy of the presentation? I am going to share a replay of this session afterwards with everybody. Leandri, you can just let me know if you are willing for me to add the presentation and to send that also on to everybody. Is there any other questions from anybody? Just going to give it a couple of seconds. Also, just want to mention, I know Leandri touched on the training part and cybersecurity training. We do offer cybersecurity training, and we do work very well with companies where we tailor make the training to fit their schedules and what they really require. But I do want to mention that last month we did have a session with the information regulator, and the information regulator actually stipulated that they will take the training that if you have a breach, they will take the training into account when they define your actual penalty. But they will only accept or take the training into account if it has been done once a quarter. So they have suggested that once a quarter is enough or sufficient training. Yes, I don't see any other questions. Doesn't look like it. Okay. Yes, thank you so much, Leandri. I learned a lot during this session, and I think everybody else learned a lot as well. So thank you so much for your time and joining us today. Thank you for all the participants in joining us today. And if you have any questions, you're more than welcome to contact me after this session. I will be sending the email out with Leandri's contact details as well, if she agrees to that, so that you can contact her if you also need any further information or have any questions for her as well.
Thank you very much, Liesl, and to Upskill Academy and to all the participants for attending. It's been a good session. It seems like people found it quite insightful, so I'm happy about that. And yes, thank you for the opportunity.
It's a pleasure. Thank you, everybody. Have a good day further. Bye-bye.